Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. On the 6th of May 2024, there are going to be amendments to the Family Law Act. And today we're going to do an overview of those changes so that we can start to help anyone out there that's going through the system at the moment to know what's changed, what's the same, and what you might expect speaking to a lawyer or what you might expect when you go to court or mediation. Hello, Mum.
Hello, Laura. Hi, everyone.
Now, this is a very big topic and we're not going to be able to get through everything in this episode, but we're going to do an overview first and then get into some nitty-gritty about, so what if I'm in court now? What if this happens? But let's just get straight into it because there's a lot.
There's a lot, and it's an exciting time.
It is an exciting time. And look, I think it's been a long wait for some people because we have been talking about it for a while and the government's been talking about it for a while, but the wait is over. So Mum, can you get us into these points? The first big one that they are changing is the change of equal shared parental responsibility to joint decision-making. Yeah. Can you give us a run-through of what that means, what that looks like, and how is it different to what it is now?
Okay, so joint decision-making will mean that the parents are expected to make decisions together. However, they're going to take out the presumption of equal shared parental responsibility, which people have been struggling with for 17 years, in my opinion. So I'm really happy that's gone. And if a joint decision-making order is made, then everyone has to try to join together and make the right decision, but there's no requirement that it has to be a joint decision. I don't know how it's going to look in practice, but it takes away some of what I think can be quite toxic power that one parent may have over another. If you're required, if you've got equal shared parental responsibility under the old legislation, you would have to make these decisions together no matter what.
So you're saying that, so the old one is equal shared, most people get in their orders or they're told that they have equal shared responsibility.
Yeah, equal shared parental responsibility, it's the presumption of the court. So they actually start from that position.
Even if you don't have a court order, they just assume...
Yeah.
Oh, no. So when making decisions, they assume it's a joint responsibility.
They had to, the court had to consider that was the default position. And our listeners may know of people who've told them they won't get sole parental responsibility, that it's joint, and there was a very heavy leaning towards joint, but it doesn't really work well.
So they've changed the words to joint decision making, or does equal shared parental responsibility now to joint? So the judge's default position is it's joint decision making.
Yes.
Does that mean the same as equal shared parental responsibility?
No.
Okay, so what's the difference between it?
I think that the court will give parental responsibility more to one person than another, and then they have to consult with the other parent. But if there's at least one person has the role. We haven't seen how it's going to pan out yet, Laura, but we think the court, like in the old days, someone would get parental responsibility, probably the people with whom the children live most, and then now that's just they have to consult. So there's no presumption of equal shared parental responsibility. The phrase is completely gone.
Right.
So they've put a new section in. It says they've got to consult with the other person in relation to the decision and make a genuine effort to come to a joint decision. But then they've said there's no need to consult on issues that are not major long-term issues. So major long-term issues mean, I think, change of school type, changing surname, stuff like that.
So you only, if this goes through, if this is going through, so they're saying now that you only need to do joint decisions for major long-term issues.
Yes.
And the other one, they hope everyone makes a genuine effort to come to a joint decision on other things that aren't like major.
That's right.
And so what's an example of a non-major decision?
If your child falls over, scrapes their knee, are you going to put Dettol or a Band-Aid on it or something? If your child's got a cold... Yeah, are they going to go to soccer or not? Do they need to go to school today or not? Are they sick? And really, this used to be the way it was. Now there's kind of been a creep of this responsibility for equal shared parental responsibility where you actually have to answer to the other parent in the current law if your child didn't go to school for 2 days. It set up a lot of scope for post-separation abuse, a lot of anxiety for people, and a lot of breaches or contraventions of the orders in the eyes of the court. And I do remember one horrible case where the mother had 2 children, 12 and 14. The 14 wouldn't talk to the father. 12-year-old was at home. She was outside washing the car. The time for the phone call came and went, and her 12-year-old didn't pick up the phone. She ended up in court before a particular judge on a contravention application, and she was found to have contravened the act because she wasn't there to make the 12-year-old pick up the phone.
Wow.
And so it was a lot of stress for everyone when they had that degree of control post-separation. I think this, I may be wrong, but I think this is a recognition by the court that some issues are social issues. They're not legal issues.
So that's why it says a genuine effort to come to a joint decision. So as long as you can show you tried to come to a genuine effort, it's not, oh, you did not make this decision together.
That's right. Exactly right. And I mean, I've had a case in the country, not in Brisbane, where the children were going to 2 different schools because the people couldn't agree. One school went with the dad, another school went with the mother, and the court pretty quickly awarded parental responsibility to one parent to stop that happening. So, I think the court is doing a lot less reaching out beyond the decision with this. They're going, this is the law, we've made the orders, go and parent.
So just a question on that. Will there still be parental responsibility given to parents, or is that whole thing gone?
Yes. Well, see, let's look at a situation where you haven't been to court and the 2 of you have a baby. Each of you has full responsibility for that child. You can do anything. You just have the power. You don't need the consent of the other person usually. So when you go to court, the court looks at that and changes the nature of that.
Right.
So they will give one parent usually the role of being the primary carer, making responsibilities.
Are they still going to use those terms?
That's what I think they're going to do. I'm harking back to 17 years ago before this legislation changed, and that's what the court did. And generally, one person was given responsibility for the children. It really worked a lot better because that person was running the children's lives. And I heard a really awful thing the other day, and it said if you have, I think it was in that One Mum's battle, it says if the children spend equal time between the 2 households, they don't have 2 homes, they have no homes because I think they're just starting to talk to the kids who've come through this system.
And that's what gets me to the next point. So they're taking out the equal shared parental responsibility and they're changing it to joint decision-making, and it's going to be less severe by the sounds of it, less punishments if you can't come to a genuine agreement. The next one is the elimination of presumption of equal shared parental responsibility. So in other words, they're saying they're going to take it away.
Yes.
So that the equal shared parental responsibility about decision-making is going to change.
Yes.
But they're also going to take away that presumption that it's 50-50.
Yep. Now, here's the thing. So that the 2006 amendments, the ones that were being chucked out now, they required the judges to do things in a particular order. So that first had to consider whether they should spend equal time with each parent, the benefit to them, and then they also have to consider the risks to them. And then they recently introduced an amendment that said, look, if those 2 things, the primary considerations was the risk to them, to the child, and the need to see both parents under that legislation, then they added that they have to prioritise the child's safety. But it really was a Band-Aid approach. So the judges had to do that. And if they found there was equal shared parental responsibility, because it was a presumption that wasn't rebutted, then they had to find that the children should live 50-50 between. They had to consider that. And then if they didn't do that, they had to give reasons as to why they didn't do 50-50. And then they had to make sure it was substantial and significant time, and it had to include weekends, school nights, everything. Their hands were pretty well tied.
Right.
And the number of appeals, because they didn't follow what's called that legislative pathway. And for a little while after the amendments, the judges weren't applying that legislative pathway on the interim matters.
Right.
They would say, look, we don't know who's telling the truth here. And they would use what we used to use, and which I think they'll come back to using. And that is they'll use the status quo principle that the kids are better off where they are. We don't know all the facts. Let's just leave them where they are, set up some time with the other parent and get into court and have a hearing.
Right. So when you're talking about that change of the structure of the decisions the judges have to make, and we've got an episode on the best interests of the children where we talk through those best interest points. Has that changed?
Yeah, they're gone. So what it is they used to be primary considerations and then a whole raft of secondary considerations. And the primary considerations was, as I said, the need for a child to see both parents, the need for the child to be protected from harm. But then there was a whole lot of things under Section 60cc that was like the wishes of the child and need to keep with their culture and any special needs. All of those things were secondary considerations. Yeah. What the law has done now is they have made all of the considerations equal.
Really?
Yes. So protecting from harm, seeing the parent, having a relationship with the parent, their views, everything, they're all just set out in a list, and the judges can make the decision based on any of those for the best interests of the children.
Right.
And that's fantastic because that's...
What does that mean then? So for someone coming through, someone who's been through it, let's do that. So
yes.
Someone who's already been through it versus someone who's going to go through it now, what does that mean for them? What are they trying to, like if they've got let's say a violent ex and they're desperate for their children to be protected, does that change their outcome?
Possibly, yes, I think. It shouldn't have, but you would have to prove there was violence under the old legislation. So it shouldn't have changed it, but it will change it. It will because the court now has free rein to consider everything about the kids. They don't require you to rebut the presumption that it should be 50-50. So you're not going to, I think, get as many people who go into their lawyers and go, I want 50-50. Or, as we've heard, sadly, people going to their lawyers and the lawyer says, well, it's going to be 50-50. This judge never gives sole parental responsibility.
All right. So if we can think of it like this, I'm going to try and think of it like this. As justice is a scale, the lady justice holds that scale.
Yes, blindfolds.
So what you're saying is every single one of those best interests of the children things that we've done in an episode, I'll put a link in it. All those points we run through, they're all now equal and the judge can choose. So the judge might look at it and go, oh, there's cultural reasons why that child should see that parent. So he puts that, or he or she judge puts that weight on that side of the scale. And there might be medical reasons that one parent is really horrible with dealing with. And they'll go, okay, well, we need to make sure that child is being taken care of medically and that's best with that parent. So they get a weight on that scale.
Yeah.
Are you saying that the domestic violence, keeping the children from harm, is an equal weight to one of the other children's interests?
No, there are a list of things that the court can take into account, and none of them bears more weight than the other in terms of the judge being required to consider these things first.
Right.
So they can look at the whole situation and work out what's best for the children.
Okay.
And I know it's a scary thing to surrender that to the judge, but I was in practice for 18 years or more before this legislation changed. And I can tell you that by and large, I thought the judges weren't so hamstrung. They could you could look at everything and go, common sense says this shouldn't happen. Whereas under the law up until the 6th of May, a person could suddenly pop up after having no time really much with the kids, not much to do with them, and say, I want 50-50. And I think the government was a bit dismayed, and they say, we didn't mean that to be automatic 50-50 and everyone demanding 50-50, because that's been a very ripe area for post-separation abuse.
Yes.
And they said, we didn't mean that. But whether they meant it or not, their lawyers, a lot of lawyers chickened out at asking for sole parental responsibility, and the judges, I don't think, were being asked as often to make an order for sole parental responsibility. And so it became a kind of an avalanche of it's 50-50, 50-50, 50-50, and the poor kids are stuck in the middle.
Let's run through these other ones and then I'm going to ask you some questions so you can
fire away.
Make this a bit clearer for everyone. But the other changes, Mum, is the codification of Rice and Asplund. Now, if you've been a long time listener, you'd know what Rice and Asplund is. If you don't, we do have some episodes that touch on that. You can reach out to us at thedivorcecourspodcast@gmail.com, or you can go to our website, thedivorcecourse.com.au/blog, and then you can just look up in there for Rice and Asplund and you'll find some episodes on that.
Yep.
Now, Mum, what does the codification of Rice and Asplund mean?
Well, Rice and Asplund is a case, and it was judge-made law. Like, it was a case that was decided back, I think, 1978, 79, and the courts are applying it because it's a precedent case. It was never in the Act, and now codification means they've put it in the legislation.
Right. So it's now a law, basically.
Yes.
So could you explain really basically what was Rice and Asplund?
Rice and Asplund said that if you've got an arrangement that's working for the children, if you've got a court order that's working for the kids, then you can't go back to the court and ask them to make a change to it unless there's been a significant change in the children's circumstances.
Well, that's great. So that's going to stop that post-separation abuse of constantly being dragged to court.
Well, that's right, because whether Rice and Asplund applied would have to be decided by the judge, and they could say, oh, that doesn't apply or this does apply. I mean, people will still try, but the court now has it in black and white that they have to consider what significant change there has been.
Right.
I think the biggest benefit of it, Laura, is for people trying to navigate this legislation and the process on their own, because it was kind of a mystery thing. Rice and Asplund. Yes. Yeah. And if you knew, you knew. And if you didn't know,
you didn't know.
You didn't know. And
not really.
You wouldn't find out till you got into court. And the other person might pop up, the other lawyer, and say, Your Honour, this Rice and Asplund applies in this case. And they want it chucked out. Whereas now it's in the Act, you know it's there. You know you have to address that issue.
Right. So that's for anyone who's wanting to go back to court after they've already got court orders. If something really bad happens or something crazy changes and the orders just don't work, significant changes, you've got to go back and get a change.
Now, it's really interesting because it's a 1978 case from memory. And they started, I had never heard of it, even as a specialist family lawyer. I hadn't really heard of it until 2006 when they introduced the previous amendment, which was that presumption of equal shared care and presumption of equal time. And when the law changed to that, the court was worried, or the government was worried, that everyone who had orders that weren't 50-50 would try to go back to court to get them reheard and get a different outcome. And they were trying to think how to stop that. And they dug through the cases and came up with Rice and Asplund. The premise of Rice and Asplund is that repeated court appearances are detrimental to the children.
Yeah.
And so suddenly we were applying this case law, as we have been, for the last 18 years or so, 17 and a half years, and now they've put it in the Act. So it's less mysterious for people. That's all. Yep.
Okay, good. Now, the next one. And I do have so many questions about all of that because there are going to be people listening to this who are like, oh, can I go back? But we're going to do that as another episode. Down, The next change is, and this is an interesting one, a revamp of the independent children's lawyers provisions, including a mandatory meeting with children 5 and over. That's huge.
It is.
I thought the ICLs weren't ever allowed to meet the kids.
Well, when I was an ICL, the only time I ever met with the children was in the presence of a social worker.
Okay, so an independent children's lawyer is appointed
by the court
to represent the children, even if the other parents have lawyers. The court appoints an independent children's lawyer for the children. What is that to make sure that the children are being heard? Their interests are being considered.
So the case is RECAE that set out the guidelines, and it's where there's very high conflict. The court may think the parents hate each other more than they love their children and are going to lose sight of the kids' wishes. If there's a proposal to separate the children, the court will normally appoint an independent children's lawyer. If the parents have mental health or drug issues or any reason that the court thinks, I need the assistance of an independent lawyer for the children, and that lawyer used to issue subpoenas, talk to the children's schools maybe, or gather the information to present to the court that the parties might not have dragged out and given to the judge. So the judge gets a full picture. But one thing we never did normally was meet with the children, because a lot of lawyers, like I had 6 kids. I'm cool. I was cool with interviewing children, I thought.
Yeah.
But a lot of lawyers are just
They
scary.
don't need kids.
Well,
So-
and it could scare the child, but
Why have they put it in?
because I think they think the children have not been properly heard.
Yeah.
So if you get a family report, the kids' wishes come to the fore.
Mm-hmm.
If you get a little report, a best interest report or something from the court, the children are usually heard, child inclusive mediation. But the ICL who apparently represented them never got to speak to the kids.
Mm.
What worries me a little bit about it, to be honest, is that if the children tell an independent lawyer something, then that's something that's happened, and that might be the only person they ever tell. That makes the independent children's lawyer a witness in the case to get their evidence before the court.
Well, how does that work?
Yeah, I don't know. Because if that happens, if your lawyer becomes a witness in the case, they have to stop acting for anyone. They have to take the role of a witness and not the role of a lawyer. And so that's one worry I've got. The other worry is there are some pretty scary lawyers out there, and the children may clam up or feel pressure. And if they're in the middle of a family dispute, chances are they've already been interviewed by a report writer or 2 or twice, or they might have had psychological assessments or anything. And this is just yet another layer. Yeah. So the court, I think, feels that the children don't feel they are being heard. It's not that they're not being heard, because that comes to the court through those family reports. But I think there's a risk that the children will freeze when they know it's a lawyer. They're not going to meet them, I dare say, in a room full of toys like the family report writers. And then the kids may find themselves under pressure from the parents to tell the independent children's lawyer that they want to live with mummy or they want to live with daddy.
And unlike a family report writer who's got some sort of social work qualification or psychologist, the children's lawyer is just a lawyer. So they're not going to be able to pick up if the kid's been
They're not trained.
drilled.
Yep. And actually you couldn't think of more different professions of law and psychology. And the only place it really overlaps, I reckon, is in family law.
Right.
So I would like to think that independent children's lawyers get some training about how they interview these kids.
Yeah, that's good. That's a good recommendation. If anybody from the media is listening.
Queensland was very unusual for an independent children's lawyer to meet with the children.
Yeah.
But in other states, it has become the practice.
Okay.
So for some states, it's not going to be that big a change.
Right. Okay. All right. The next major change is the simplification of the contravention provisions and penalties. So that's if you've got an order and someone's not following it. How do they simplify that?
Yeah. Well, I don't know that it's a simplification.
Oh, God.
There used to be like three levels or 3 or 4 levels of breach, and you'd get, if you did it once, you might they might order make-up time. If you did it a second time, you might get community service. If you breach a third time, you might get a fine. And then the ultimate one was jail. They've tightened up those provisions because of people who get away with too much, and the law was very hard to apply. It was a quasi-criminal thing. So that's all very well. It's all well and good. But what I like about what they've done, with all due respect to the government, what they've done is allowed a judge to change the orders at any time. And so if someone goes before the court with contravention concerns, it might be that the judge goes, oh, that's I can see that's ridiculous. I'll make an order right now that child doesn't go, or I'll make an order right now that child goes to that parent for make-up time for 3 months. So instead of you having to go back to the court with an application to change, the court at any stage now can make an order.
Okay.
Yeah.
Now, this next change is probably good for anybody dealing with post-separation abuse. It's the addition of a harmful proceedings order to vexatious litigant provision.
So
you could find us on Instagram, Facebook and TikTok. We're there waiting for you right now. If you want to get more out of the Divorce Course, all you have to do is go to the Divorce Course podcast at Facebook or TikTok, or the Divorce Course on Instagram. There we share bite-sized pieces of information and bite-sized inspiration and motivation to help you through this difficult time. Come and join our community and let us know you've joined. We'd love to see you there. Now, this next change is probably good for anybody dealing with post-separation abuse. It's the addition of a harmful proceedings order to vexatious litigant provision.
So a vexatious litigant it's very hard for a person to be so bad they get classed as a vexatious litigant. But the court has always had that provision, okay? And the vexatious litigant is someone who just brings application after application after application, usually with no merit, usually to harass the other person or because they can't take no for an answer from the court. And so the court has clarified that now. There's a new section called 102 QAC. Oh, bless us.
Quack.
Quack. They don't want to add new numbers because we all know 102 is about vexatious litigants, so they just keep adding alphabets to it. So the court can make an order. Proceedings are harmful if the court's satisfied that the other party or even the child would suffer harm if more proceedings are commenced. And harm means like psychological harm or oppression, major mental distress or a detrimental effect on the care of a child or financial harm. Now, that is a brand new section, and it makes it very clear what criteria the court can use. And it is in there solely, I think, for the post-separation abusers out there and for the court to draw a conclusion on those things, that it's bad for the kids or it's bad for the other person, for these proceedings to keep going. So what they do with that is if the court makes a harmful proceedings order, then the party who is the subject of it can't file anything automatically online and keep like applications going. They have to actually apply for leave to begin new proceedings, and the court may not let them do it.
Right.
And in some cases, I think they can make it that it's done in the chambers, right? And they can dismiss the application in chambers, and the person who is going to be subject to stress if it proceeds will probably never know.
That's great.
Yes. I had one matter once years ago where I had so many applications that one day, it was the 12th of January, I remember, straight after the holidays, I had 5 different matters on from this one person, and I was representing a woman who was overseas. And after it was all over, someone in the registry told me they were calling me Mrs. what my client's name was because I was up there all the time on this case. And I said, I couldn't believe how many this man filed. And she said, you should see the ones the registrar wouldn't file, so they were already operating a little bit that way. But this allows the judge, so if you've got a judge, they'll have a look at it and go, this is rubbish, this is just abuse, and chuck it out.
Okay,
it's good.
That's good. That's going to stop.
That's the coercive control post-separation
Those
abuse.
people that are constantly being dragged to court for silly reasons.
Yes.
Even just going in there and the judge saying this is a silly reason and throwing it out, you still had to have gone to court.
Yes.
So that's going to take that away, which is great.
Yeah. And don't forget we've got the central practice direction, which is the 4 core principles.
Yeah.
And in that, rubbish applications to the court may result not only in a costs order to the person who brings the silly application, but also probably to the lawyer, possibly to the lawyer who files it and fronts up when they know there's no chance.
Yeah, that's great. Now, Mum, this last change, and then we're going to have to do some more in-depth episodes to get our heads around these individual points, but it is the revamp of the S121 publication restrictions. So I'm guessing that's talking about your case? Is that what that is? In a way,
well, mostly what it is, the change that they've made is to allow you to share your family report, really. So what they're worried about is they don't want you sending stuff to the open public. It's an indictable offence to talk about family law proceedings to the public if it identifies a person, okay, or a person concerned or a witness in those proceedings. And it's also an indictable offence now to even send a list of the court cases that day to another person, okay, that identifies the name of the people. And it also, there's some exceptions to that you can give it to, significant legitimate people who've got a legitimate interest greater than the interests of the public. So you could do private communications to family and friends and all of that. And
so just to be clear, you're still allowed to talk about your case with your family and friends?
Yes, except those things.
Your family and friends can help you with your documents and all that sort of stuff, but you can't put it out into the social media world?
Yeah, that's right.
Yeah.
So it's always been under Section 121 of the Act an offence to share documents with other people, right? But now they're saying, look, that's really the public, really, and it doesn't include if we're talking to a person with a legitimate interest and in the subject matter of communication that's greater than the interest of the general public. The law was, as I understood it, that a family report couldn't be shared with anybody. So if you had, so the people who were the parents, for instance, and their lawyers and the court were technically the only people allowed to see the family report. The logic behind that was that sometimes some pretty hard home truths are stated in there. And if you showed that to your friend about the other person, that damages their reputation. And also, though, like ripples in a pond, it kind of expands the dispute. People start like talking about the things, the findings in the dispute. So I don't know why they are letting you do it, except that it was pretty lonely.
Yeah,
you couldn't get the support of your husband or new partner or your mother.
For those vexatious kind of litigant people, if they found out that you did share that report with your friend or your family, they'd take you back to court as a contravention, I guess. So I guess
and it
I
came
can
up,
see why they did that.
Yeah, and it also came up a lot in cross-examination at final hearings because barristers would use it as a way to catch a person out in the law. And they'd say, so you've read the family report, haven't you? Yes, I have. And you've shown your mother, haven't you? Yes, I have. Well, do you know that's an offence? But it's not anymore.
Right.
Okay.
But you can't go blasting it around social media or the public.
Or letterbox dropping it or anything. It's got to be a legitimate interest. My recommendation to you would be to have a hard copy. If our listeners, you'll get it as a soft copy emailed.
Yeah.
But I think if you want to show anyone else, print out a hard copy and don't forward the email because you don't know where that's going to end up.
Yeah.
And I think
only show family and friends that need help with.
Yeah, or who are relevant to the proceedings.
All right. So, Mum, basically that's a lot, and that's not even all of them. They're the major changes. So there's the change of equal shared parental responsibility to joint decision-making.
Yeah.
There's the clarification that joint decision-making order is made. It obliges consultation and a genuine effort to agree on long-term decisions, but there's no requirement for the decision to be made jointly.
Yeah.
So that's going to take a lot of pressure off a lot of people. They've eliminated the presumption of equal shared cared parental responsibility. So that's also going to be helpful for a lot of people. There's a change to the best interests of the children. It's putting it all together in one list. It's not prioritising those two, harm and the need to see the family. Then there's the codification of Rice and Asplund, so making it quite clear what you need to do in order to get back into court.
Back to court. Yep.
There's a revamp of the independent children's lawyers provisions, including being able to meet the kids.
Yeah.
There's a simplification of contravention provisions and penalties, so they've made it a bit more easier to
it's easier to understand.
Yep. There's the harmful proceedings order that's going to stop post-separation abuse, hopefully.
We're hoping that.
And then the revamp of who you can show your stuff to, so you're not alone.
Yes, but don't show your kids.
No, of course. So now there's a lot of implications there, but just to clarify just this one thing, and then we're going to do a whole clarification where I'm going to ask you a bazillion questions about what this means and what does it mean for people who are listening. But for everyone who's listening, just so we're clear, these changes do not apply to anyone who already has an order.
Unless there's a significant change and you overcome the presumption that more litigation is bad for the children. So you have to show it's so important that it's better to have more litigation. The court's going to try and shut it down. Yeah.
So the other question I've got for you, if they've got joint parental decision-making,
they're stuck with it.
They're stuck with it. Right. Okay. But on the positive note, you as a whole are feeling quite positive about these changes.
I am. It's kind of back to the future for me.
Yeah.
But I think that why the old routine prior to 2006 wasn't working was that it took a couple of years to get to a trial, 3, maybe 4 years, whereas now the courts have tightened that up and it's generally a year, if that. So when you had your interim orders for the kids, you were stuck with that until the trial, and the court was applying a kind of status quo thing, saying, why would we disrupt this? It's been 3 years. So it was almost as if your interim orders were going to become your final orders, whether you wanted them or not.
Yeah.
And so there were multiple applications. Sometimes people file 5 or 6 times this has happened. Can I have another night? Oh, we've been doing this well for a year. Can I have another night? And so the courts sort of now condense that. So they may start applying status quo again, and that is where the kids are on an interim basis. We haven't got time to listen to all the evidence. Let's just leave them there and sort this out at trial in 12 months, 10 months, 11 months. And I think that is going to undo a lot of the harm that the men's rights groups, frankly, got up in arms about. Those changes in 2006, and I probably offend some people, but I've looked at the submissions to the court, to the Law Reform Commission about those, and it was men's rights groups, men's advocates by almost 6-2. You know, there was one for separated parents, one person represented them, and that presumably had some women in it, and there was one for women, but the rest were,
you think it might have tipped the scales in the wrong direction for fairness because it was an unbalanced.
Too right.
Unbalanced when they decided to make those decisions. But now,
and you'll hear them complaining about this law.
So now that they've kind of rectified what they've seen as an issue, and you've seen some of those groups be up in arms now.
Yes,
because they're not happy with taking it really back to what it sounds to me like taking back to the core of the children. It's about the children. It's not about the parents. It's about the kids.
And, when the government legislated these changes, they still have that the best interests of the child is paramount. But everyone has just started at the primary consideration, So they still have the international rights of the child sort of phrasing there, that the object is that children, should be loved and cared for by both parents and have involvement with both. But then the judges' hands aren't as tied as they have been. So it's going to be massive. I'm really, really pleased about it.
Okay. Well, we will dig deeper into this to see how this is going to affect you and your case or what you're doing at mediation and things that you can maybe be considering because, Mum, they've said that even though it hasn't come into effect yet, that you need to be considering this.
You do. So we're recording this in April 2024.
Yeah.
And we've just had an email round from the court saying that even if you're filing before May 2024, 6th of May, you may not get your consent orders made in time to get under the old legislation, and the court will be applying the new legislation as and from that date. So if you've got orders, you should be getting them filed, if you're listening to this in real time, into the court if you want them to be made before the 6th of May, because if you're going to do it after the 6th of May, you have to address the changed legislation. And if you think your application might not get heard until after the 6th of May, the court says you've got to address these changes now. So we'll get some precedents up and put them up.
Yeah.
And those people who are doing our course will be able to have access to those.
Yeah. So it's a little bit wild westy at the moment?
It is. What we've got, people who want 50-50 equal shared care are rushing to court and agitating like crazy to try and get that through before the law changes.
Right.
And people who don't want 50-50 shared care are dragging their heels and doing everything they can to not have it heard under the old legislation. I would say when we're here in a position of about a month before the orders change, any application you file that isn't consent orders is going to have to address these new concerns. So you need to look at the new sections of the Act and make those headings for your submission.
Okay. All right. Well, thank you, Mum, for that. Thank you for explaining that to us. It's hard to understand, and we're going to get into some questioning about what each bit means, but thank you for that brain of yours, wrapping it around this massive amounts of pages that you've been looking at and studying for a while. So thank you, everyone, and wishing you all the best. And this is good news. Onwards and upwards.
Yes. Bye, everyone.
Bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.